Hey guys, welcome back to Study Time Anytime YouTube channel and continuing the series of the case laws. The ninth case law which we are gonna read today is the right to be taught in French. Jean-Claude May, Paul Dewey, and Angela Martel were three French-speaking parents who argued that French language education in Edmonton, Alberta was inadequate. They submitted a proposal to the Minister of Education for a new French elementary school that would be administered by a committee of parents within a separate French school board, among other features. The minister told them that it was a policy of the province to not create any French school jurisdictions. The parents then submitted their proposal to two other school boards, but their proposals were rejected. May and the other argued that their minority language educational rights were violated. Specifically, the right to a francophone run education system was violated. The Supreme Court found that the minority language parents have some control over the education facilities in which their children are taught. It concluded that minority language educational rights guarantees these parents the right to manage and control a minority language school and that adequate public funding must be provided for this purpose. The guarantee of these rights would ensure protection of a minority group's language and cultural identity. So in this case, Supreme Court propounded that minority language, minority status, minority minors, their culture, their language, their identity should be promoted by the state, and adequate public funding should also be provided in case the minors face any kind of problem in facilitating or preserving or giving it further to their children or promoting the same. So the case was May versus Alberta. It was decided, it is the case in 1991 SCR 342. Next, the 10th case that we are studying is hate speech towards targeted groups. The brief facts are James Keckstra was a high school teacher in Alberta who taught his students that Jewish people were evil. He also denied that the Holocaust occurred and said it was invented by Jewish people to gain sympathy. Keckstra was convicted for promoting hatred against an identifiable group based on these statements to his students. James argued that criminal code prohibitions on hate speech infringed his freedom of expression. Supreme Court confirmed that the Charter protects all forms of speech, including hate speech, so long as it does not include violence. However, the majority of the court concluded that the limits the criminal code placed on James' freedom of expression were justifiable. This is because the limits aim to protect groups targeted by hate speech and to promote positive relations in a country dedicated to equality and multiculturalism. The case serves as a reminder that freedom of expression is not absolute and can be limited in situations where there is need to balance competing interests like respect for difference, equality, and multiculturalism. So, R versus Keckstra, 1993 SCR 697 is the case title. Next case is evidence in trials. William was a Calgary lawyer who was charged with breach of trust, theft, and fraud. A witness had given evidence to the prosecution that would have helped his case. However, the prosecutor refused to give it to him despite repeated requests. Supreme Court decided that by withholding this evidence, the prosecution violated the rights under Section 7 of the Charter. This is because Section 7 protects the right of accused person facing potential prison sentences to know the case against them, so that they are able to defend themselves. The ability of an accused person to make full answer and defense to the charges against them is essential to protect trial fairness and the truth-seeking function of a court. The case was sent back to trial so that William could be fairly tried. This decision had a significant impact on increasing basic fairness in the criminal justice system. As a result of this case, the prosecution must now make all relevant information about a case available to a defendant. So in this case, it was held by court that a person who is accused of an offense is charged by the court. It is necessary to give entire information about what charges and on what grounds the charges have been framed against him, so that he can protect himself by making full answers and defense for the charges against him. It is essential for the fairness of the trial and for the better functioning of the court. So this is the case title below, which was held in the year 1991. The next case is the right of the accused with mental disabilities in criminal trials. Owen Swain was arrested in 1983 for attacking his wife and children and was charged with assault and aggravated assault. Fortunately, they did not sustain any serious injuries. At his trial, Swain testified that during the incident he believed he had to protect his wife and children from devils. Swain moved from jail to a mental health center where doctors prescribed him antipsychotic medications, which improved his condition. Swain was granted bail, released into community, and continued to take his medication and see a psychiatrist. Swain remained out of custody until the conclusion of his trial. Applying the judge-made rule at the time, court allowed the Crown to offer evidence of Swain's insanity. At the end of the trial, Swain was found not guilty by reason of insanity. At that time, the criminal code required that he automatically be held in custody until the lieutenant governor of the province decided to release him. Swain's defense counsel challenged the constitutionality of both the judge-made rule and automatic detention under the criminal code. The Supreme Court found that it was contrary to the fair trial rights, including the right to control one's own defense, for the Crown to raise the defense of insanity during trial if the accused does not raise issues of mental capacity. In addition, the court struck down the automatic detention scheme since it deprived the accused of liberty based on arbitrary standard. There was essentially no standard at all and without adequate procedural protections. As a result of this decision, Parliament modernized Part 20.1 of the Criminal Code to ensure accused with mental disorders are treated fairly by the criminal justice system while continuing to ensure public safety is protected.